Good morning, everyone. I would like to thank you all for virtually coming to this first panel of this webinar series entitled Empowering Perspectives, Unpacking the Brazilian Industrial Property Law. In particular, I would like to thank the Young Scholars Initiative for providing all the means for this webinar to take place, as I am organizing it together with the Finance, Law and Economics Working Group. And I would like to thank also the Future Law and LAPI UFRJ as co-organizers of the event. This webinar series is based on the book Comments on the Brazilian Industrial Property Law by Women, a book that was recently published by the Thomson Reuters, which unfortunately so far only has the Portuguese version. Therefore, this webinar aims to bring some of these women authors to talk about the Brazilian IP scenario in the English language for national and international stakeholders. It was the first time that we had such a piece of work authored and organized by women in Brazil and maybe in the world. And therefore, it is also the first time that a webinar series is exploring and following this path. Today, we are going to discuss especially patents and a bit of industrial designs. As the title of the panel is as follows, Shaping the Future, Discussing Patents and Industrial Designs in Brazil. I am Deborah. I am an IP and competition lawyer and a specialist in the economic analysis of innovation and intellectual property. And together with me, I have Ana Cláudia Mamed Carneiro and also Renata Angeli. And now, going for the discussions, first, I would like to explain the agenda. We'll have two expositions of 15 minutes each. Then, with the remaining time, we will take in some questions. So please feel free to write your questions through the chat here on the platform during the presentations, and we will read them timely. That said, I would like to introduce to you the first speaker of the day. Her name is Ana Cláudia Carneiro. She is a chemical engineer and a partner at one of the biggest law firms in Brazil, especially in IP, the Dynamon. And Ana Cláudia, the floor is yours.
Thank you very much, Deborah, for the introduction. Thank you for the invitation to participate of this very important and interesting project webinar, especially based on a book wherein we have the authors. All of them are women. So I will focus my speech on patent, and then I will cover brief topics on the industrial design. I am the author of the chapter related to patent, not industrial design, but just to bring and add information to the audience. I will bring a general picture of the prosecution and key issues related to industrial design. Okay. So this is I'm taking this opportunity in a very close manner. I will not share slides with you. So I have here my bullet point just in hands. And it's a way that we are going just to talk, change the experience, and then we will have the opportunity to receive questions, comments from the audience. Generally, patent provides protections for a technology in all technical fields, chemical, life science, mechanics, IT, any kind of technology may have protection through the patent system. So in one side, we have the government who provides a title to the patentee, a property title, temporary, it's temporary, nowadays 20 years from the filing date of the patent application, and on the other side, we have the patentee who will receive this right, we will have this right granted from the government as a way to have a reply to all the investments that uh, a university, research institute, small or big Brazilian or multinational companies. All these actors can be the patentee of a patent. So, and the society, it's very good for the society because the result of the patent system is to have the improvement of the technology. And so, differently from what we call the industrial secrecy, wherein the technology is kept under secrecy, the patent is published. So, if you file a patent application, it's going to be published, and everybody will have information on that invention. And this publication is an event that promotes the development of technology. So our technology becomes aware for the society, and then improvements over no patents generate new patents, and so this is the way that we have improved the technology in all countries. So this rationale, this result is obtained in all jurisdictions. So talking about the prosecution of a patent application, after filing, this application is published, amendments can be filed, and then we will discuss in more details this part of amendments. But the applicant can file amendments until the request for examination based on the originally disclosure of the patent application. And within 3 years from the filing date, the applicant must request the examination. So here in Brazil, differently from some jurisdictions, we need to say to the Brazilian Patent Office, hey, please examine my application. Okay, you pay a fee, and then the examination, the Brazilian Patent Office will understand that the applicant is interested in the examination, and he is going to move forward with the examination under the prosecution timeline. Uh, Once this examination is requested, the examiners will issue technical opinion. Nowadays, we have the so-called preliminary office action. It was a tool which has been applied in Brazil for some years, and it's very helpful. Why? Because the patent office checks the prior art raised in technical opinion in jurisdictions, in other jurisdictions. I would say basically the most five players, the five most famous and biggest players in IP patent: United States, Europe, Japan, China, and Korea. So general examiners will take a look on the examination in these jurisdictions, check the prior art cited, and they prepare the office action. Okay, so without comments on the merits, it's very helpful. So the applicant receives this opinion and we will reply by making amendments, by harmonizing. It's a possibility to harmonize the Brazilian application to a patent granted abroad. So, and the result of this procedure is very good. Why? Because after replying this preliminary office action, several patents are directly granted. Okay, so this is a tool that enables a more quick examination. And we also have the issues of technical opinions on the merits, wherein the examiner will discuss the patentability requirements, the novelty, inventive step, and industrial application, clarity and precision of the claims, and also enablement of the invention, which basically represents to an evaluation if the description of an application is clear enough, is provides enough and full information to enable a skilled person in the art to reproduce the invention. Okay, so after this examination on the merits, the examiner the examiner may issues 1, 2, 3. I would say that 2 OFC actions is very common. And then the examiner will publish the decision. This decision may be the allowance of the application. So if the application is allowed, the applicant pay the final fees and the patent will be granted. The examiner may understand that the application doesn't fulfill with all the requirements and will publish the rejection with the right of appeal. So then this case will go to the second instance in the at the patent office. During all this prosecution, if there is an interest from the applicant to have the examination accelerated, there are several programs here in Brazil. They are very efficient, the results are very good. And so there are several programs wherein the applicant may request the acceleration of examination. Just to give you examples, in case the product is in the market, in the Brazilian market, and you proved and you provide documents and information to the patent office, so your case can just jump on the line. Another alternative in the health field, if the invention is related to the treatment of cancer, HIV, rare diseases, or neglected diseases, basically I would say tropical diseases. Another possibility is if you file firstly the application in Brazil, then you extend this protection to abroad, even through the filing of a PCT. So just the filing of a PCT is a demonstration of going to other jurisdictions. And then you can also have request the acceleration of the examination in case there is a potential infringement in the market. So it's a very good reason to have a decision as soon as possible. And so here we have some examples, okay? And in case the application doesn't fulfill all the requirements of different programs, judicial measures can be studied and may be applied. So now I would bring from considering all this step of the prosecution, I would highlight one that it's very and deeply discussed here in Brazil. That is the filing of amendments in the application. Our law in its article 32 establishes that the applicant can make modifications in the application until the request for examination based on the disclosure of the application as originally filed. But this is the law, and so it's this wording allows amendment until the request for examination, but don't prohibit amendments after the examination. And one day a resolution 93 was published, and it basically establishes that amendments after the request for examination cannot broaden the scope of protection and cannot have a new category of claim included. So it was very complicated in the beginning and until today. Okay, so this discussion is very intensive, and it's also extended to the divisional applications. So the results of this resolution, this practice on restriction of amendments after the request for examination is that the applicant, so rejections, discussions before the courts, and especially when we consider Brazilian local small companies, universities, research institutes that dedicate much efforts to understand, to incorporate the culture of IP, but they need a great support. So the difficult in understand this practice, these provisions of the resolution, the interpretation of the patent office, we see there it's an impact and an desired impact, but it covers all profiles of applicants. Okay, just to be very clear, all the applicants are affected by this, and so discussions on this rule have been discussed before the courts. Okay, so it's you can see how complex this discussion can be, and these rules also applied to divisional applications, and it's another problem because our law established that to file a divisional application, it's basically required two conditions. The first one is just to link, to indicate which is the original application, and then to be limited to the originally subject matter disclosed. Also, we have discussions before the courts on the filing of divisional applications. And as a proof of the importance of this point is that the national strategy of IP discussed several aspects of the IP law, and one of the aspects was the amendments and also filing the divisional of applications. So government, national and multinational companies, universities, all the stakeholders discussed very deeply this, and we will still be discussing for the future because there are different interpretations on this aspect. So this is a general picture of the patent, and I will now just cover a very quick information on the industrial design. Differently from a patent, the industrial design focus on the protection of the design, the lines, the forms, and not functional features. Patents are focused on functional improvements of technology. It's a much more simple procedure, industrial design. Basically, you'll find the designer. After a few months, you will have the register. This design will be registered by the patent office without the examination of the merit. It's something that runs smoothly, but the applicant can request the examination on the merit. And this is the recommendation if you have a design, very important, strategic. It's recommendable. It's recommendable to request this examination, because if you need to discuss a licensee, or even if this design will be object of a discussion before the courts, it's important to have the Brazilian Patent Office. The validity term of industrial design is 10 years from the filing date, and then more 3 consecutive periods having 5 years each one. So industrial design in Brazil can be protected during 25 years, considering all these periods. So this is my experience, the main aspects that I would like to cover, and I will be glad to continue the discussions with you. Thank you so much.
Thank you very much for your exposition, Ana Claudia. There is a lot to discuss on this subject. Very much looking forward to the debate after Renata's exposition. And well, following the agenda, I would like to introduce to you Renata now, Renata Angeli. She's a professor at the University of the State of Rio de Janeiro. And also she's a technology board advisor at the Carlos Chagas Filho Foundation for Research and Support of the State of Rio de Janeiro. Renata, the floor is yours. I think we can't hear you. Wait. Yeah, I think now.
Hi. Okay. I would like to thank you for the invitation to speak at this event. I'm very happy and honored to contribute to a discussion of intellectual property in Brazil and around the world. In Brazil, there is no IP culture, and this is why our country has many problems due to lack of knowledge about IP. Still, for innovation, understand IP is essential. That's why it's so important to discuss this topic. And I'm a degree in biomedicine from Federal University of Pernambuco, master in biological sciences from Federal University of Pernambuco too, doctor in biochemistry from Federal University of Rio de Janeiro, and I changed my research subject in my postdoctorate, and I live at the laboratory, and I did my postdoctoral in intellectual property innovation at TTO, the Technology Transfer Office from Federal University of Rio de Janeiro. Now, I'm an associate professor of entrepreneurship and intellectual property of State University of Rio de Janeiro, UERJ, permanent professor of the master degree in environmental science and technology, UERJ 2, and permanent professor the master degree in intellectual property and technology transfer for innovation, guest professors of the postgraduate program in biological science, UFPE, and I have a fellowship with the project From Bench to Startup, Promote Innovation and Innovation Internship in Biotechnology in the context of the Entrepreneurial University. And I have a research group called the University Movement for Development, Internship and Innovation. In Portuguese, the name is Mudei, that means change. And I advisor in FAPERJ. FAPERJ is a state foundation to support science, technology, and innovation. And there I coordinate notices for innovations for companies and technology research. Today, our analysis will focus on the intricate details of your articles 37 to 45 of the Industrial Property Law, addressing crucial issues related to the granting, validity, and protected afford patents. Sorry. We start in the process with deposit after formal examination to conference the documents, this figure, how to flow chart of a patent application. So deposit, formal exam. The patent application is published, and you have the technical exam. The technical examiner judge. Then an order does not meet legal requirements, a window of opportunity opens. The applicant has 60 days for the publication of the rejected decision to file an appeal. This phase is not a finished decision, and interested third parties can strategically present objections over the next 60 days. After analyzing the appeal and counter reasons, the president of the INPI, our Instituto Nacional da Propriedade Industrial, our office, may decide to maintain the rejection, request new
New documents in this case.
Yes, the new documents, and sorry, I need to stop 1 minute. And we like rejection when the technical examination determines approval. This decision is final. It's not subject to appeal. Once the patent is granted, here, critical deadlines arise for the payment of the final grant fees. Now, I will go to talking about validity, Article 40. Article 4 establishes that the invention patent will be valid for 20 years and the utility model patent will be valid for 50 years, both counting from the date of filing. We highlighted that of the grant that is relevant, it is the deposit date that determines the validity of the right. Until 2021, Article 40 had a single paragraph that granted compensation to the holder when the process is set half the time stipulated by the general rule. This aimed to mitigate the effects of the famous INPI backlog, where prolonged analyses were common. For example, in this picture, the deposit of invention patent was in 25. So your concession is a 2021, and this patent is valid until 2031. So the validity during 26 years. The constitutionality of the single paragraph was questioned by Supreme Court, our Supreme Court. So the Supreme Court decided to revoke it, arguing that the indefinite distinction it's not a benefit to the monopoly holder, harming the social function of industrial property. Maintaining the deadline extension already granted, except for pharmaceutical patents and those involved in legal action until April 2021. These protective effects already implemented such a measure against infringers or royalty receivers. In these figures, we can see how the country was harmed by this problem. We average period of validity in 24 years. Only 7% of patents respect the time of the law. And Brazil is the country in which we have the longest period of validity. It is important to mention here that INPI has made programs to combat the backlog. Finally, the protection, Articles 41 and 45. Articles 41, scope of patents protection is based on the claim supported by the descriptive reporter. Article 42 highlights the central benefit of the patent, the right to exclude third parties without authorization from producing, using, selling, or importing the patent product. It is important to note that the holder can prohibit not only the use of the process, but also practice related to the products obtained by the patent process. The reverse of the burden of proof occurs in action involving process patents. 43 are exceptions, like, for example, research proposals. 44, compensation for infringement and prior non-development, establishes that the holder is entitled to compensation for infraction committed between the publication of the request and the grant. And Article 45 ensures that the previous user can continue exploring the invention free of charge as long as they maintain the same provision conditions. And to remember, we have this figure that show the patent grants by origin, country, and field of technology. So patent grant in 2021, 18% of patent grants were issued to applications for 6 countries: China, USA, Japan, Korea, and another countries. So only China has top 29 fields. And in this another figure, we have the largest patent application in Brazil are non-resident in all fields. So we need to talk about this. Thank you.
Thank you very much, Renata.
Much.
Well, now moving to questions. If anyone has questions, please feel free to write it down on the chat. Meanwhile, I would like to address a question before to Ana Claudia. Specifically, Ana Claudia, when we were talking about the Article 32 and the Resolution 93, in the article that is part of the book, you were suggesting that probably the Brazilian Patent and Trademark Office might be hiding innovation when we have this contrast, right, in law. So I would like to actually have your opinion, if you can share with us some examples on how can we address this challenge brought by this contrast between the Article 32 and the Resolution 93, when we talk about how small companies and universities can face better this challenge. For instance, you mentioned that there are some dialogues and the Brazilian IP strategy. So I don't know, like in your opinion, what would be the best way to?
Thank you, Deborah, for the question. In terms of strategy, so your last comments in your last aspect is in your question. The best strategy is to follow the plan A, what I call plan A. Before you request the examination, take a look in the set of claims to check if it's covering all the alternatives, all the scopes which might be of interest. An example. Let's suppose that we have a patent application covering a product, a drug, cosmetic, agrochemical, and a process for producing this product. If I just claim the product and request examination, I will not be able to include claim for process for producing this product after the request for examination due to the interpretation of Article 32, which covered by Resolution 93. So the plan A is take a look in everything, and I would say product, process, use. Okay, basically these are the broad 3 key categories. But sometimes the applicant doesn't have this information in a clear manner and request the examination. So in this example, if the applicant wants to also have the protection for the process, he would have a very complicated fight to discussing this with the Brazilian Patent Office. Chances low, I would say that no chances before the Patent Office, and the ways to go to the courts to discussion, and we have favorable decisions for the applicants before the courts. But how to try to mitigate this problem when we see universities, small local companies? One very good example is just we are doing here, discussing. Okay, discussing, bring experiences, bring different interpretations of this practice so that the society becomes aware and understands the impact of this practice. And as was very important, as I mentioned, the National Strategy for Intellectual Property covered these aspects. And so my comment is to incentivize this discussion, to share experience, to give webinars like this. Also, in case of a university, I know that several university has his own innovation and IP agency, which are very engaged of this, but sometimes needs a support, and this support and this information can be obtained through events like this. So study, discuss, look for information, look for different interpretations, and having in your mind that we have a restricted rule in Brazil. It's something very particular from Brazil, okay? Yeah, and proof of this is that when we talk with a university or a company abroad, it's hard for them to understand this practice, okay? So this is my suggestion.
Thank you very much, Ana Cláudia. Now, I don't know if Renata is there. I would like to address a question to her as well. Okay. Renata, so in your article, you talk about the protections of patents and talking about the protections you also talk about some problems we might have here in Brazil. So I would like to ask you, considering the detailed law provisions that you outline in the article, what challenge do you consider that patent applications commonly face in Brazil, and how can we navigate these challenges efficiently, and also with efficient and very fast, let's put this way?
We have a bureaucracy, have a lack of acknowledgement of the IP system, but our office, INPI, has made many advances about this course, this site, these initiatives to change this one. And I'm a professor in master degree to intellectual property. But we had a problem with our entrepreneurs, our industry, and our singers. They have a lot of problems with these problems with the authorial direct of not our singers. So I think that we have to do this event, to do talking about of PE, read our book, and this is.
Thank you very much, Renata.
Deborah, if I can add a comment.
Yes, of course.
Okay. This week we have the Brazilian Patent Office published a communication that will be enforced in the next almost 60 days, restricting even more this scenario on amendments. And it basically, amendments during the appeal stage will not be accepted. So if you are trying to have a patent and you make the modifications to just because you became aware during the examination and see, so I need to narrow my scope, I need to change. So what I can do to have a protection respecting the law, and so amendments are necessary. And now we will have this additional restriction in appeals, in appeal division, okay, in the appeal stage. Another suggestion, as you asked me, so what the applicants can do. So contact the Brazilian Patent Office, participate, promote events to discuss the IP. There are IP associations promoting events, also the innovation agencies of the university. So this look for and improve this discussion, basically this.
Thank you very much. Another thing that I was thinking when you were talking about the fast track, usually the fast track works very well here in Brazil. But for instance, nowadays that we have every time more startups, for instance, maybe we should think about a fast track that is specifically for startups, because nowadays we have in Brazil a fast track that is for small companies, but the startup will enter in the same fast track of small companies. So maybe having this division and also this division would improve the data that the patent and trademark office receives, and then we can improve like step by step the law and also how the law is applied in the country. But for it, we need these kind of discussions that we are having here right now. And for that, I would like to thank you both for the time. And I would like to thank you all that attended the event today. Unfortunately, we need to close the panel now. But I hope to see you all very, very soon. And thank you very much.